Good afternoon, everyone, and thank you for joining us today on our tax and estate planning webinar entitled Tax and Estate Planning to Doing. My name is Sean Kimji. I'm the Vice President of Wealth Management at Alterna Wealth and Alterna Savings. And I'd like to thank you for your time today in joining us on this very important webinar that we believe that is going to be really beneficial to members. A couple of housekeeping items. This webinar will be recorded, so in case you have questions or want to come back and visit a piece, we will have this video available, and we will be providing some collateral material as well to support some of the discussions today. Having a well-executed plan is really crucial to ensuring that your estate needs and the wishes that you have for your beneficiaries are realized in a tax and efficient manner. And so with that, we have a very special guest, Doug Carroll. And Doug, I'm not sure if you're there. There we go. Great. I think you're still on mute though. Wonderful. Who has a tremendous amount of experience in this field. I know from our membership, we have received a lot of inquiries. We continue to get a lot of questions on, what are the real issues they should be looking at when looking at, their estate, when they're looking at intergenerational transfer. What about the properties they have? What pieces they need to have in place? Because there are many concerns, especially given the current environment we're in, where members want answers to these questions for peace of mind and for the benefit of their beneficiaries. So with that, I don't want to take away from, the main crux of this presentation, but Alterna Wealth is here to provide support. We have certified financial planners and wealth advisors who can certainly work with you to, help create and understand your estate needs. I'd like to take a moment to really introduce Doug. Doug has been with us on previous webinars. But I think it's important that I really stress some of his expertise here. And, Doug Carroll is the tax and estate specialist with Aviso Wealth, which is a wealth management partner to credit unions across Canada, including Alterna. Doug previously ran a tax and estate planning law practice. Is that correct, Doug? A tax and estate law planning practice, and was an advanced tax case consultant with a life insurance company and mutual provider. He's been doing this for 25 plus years, supporting our advisors. He's written articles and he's done individual case consultations, and of course, the webcast that he's doing today. So without further ado, I'll pass it over to Doug Carroll. And folks, we do have many questions that have come in. We will try and get to all those questions. If you do have an additional question, you can put it in the chat box and we will certainly try and address them and leave some additional time at the end of the webinar. Okay, Doug, over to you.
Okay, Sean, and just to be clear, you can hear me right now. Okay, I was trying to switch over onto my AirPods because they focus the sound a little bit more, and you don't pick up the ambient sound. But I think that partially because we've got a large group of people here, and so the nature of the platform, the AirPods aren't kicking up. But I'm as long as people can hear me, then that'll serve the purpose. And so I'm going to give you a little bit of further background on me and law practice I ran, very little bit, before I launch into the topic. I will go for about a half an hour's worth of time. And as Sean mentioned, we've got a number of questions that came in advance, which we know we're going to deal with. And so that'll give us plenty of opportunity to deal with those questions. Or if you have additional questions, then you can pop them into the chat box on the session here. So just to give you a little bit more in terms of my estate planning law practice background, I started off early on and I worked for a couple of firms, articling, and then starting off with a law firm doing a variety of things, but definitely had an interest and an inclination towards the estate planning topics and the needs that people had along those lines. And I've always looked at it in a really positive way. The other thing related to that is that my undergraduate degree background is in business, and I've worked with business owners over the whole career that I've had, entrepreneurs. And so that was a lot of the focus that I had was working with people in that situation where they were looking at their personal succession, the estate planning, but also the business succession. I would see people in their homes and in their businesses to have those kinds of conversations. So this topic about estate planning and a really broad-based view of estate planning is definitely the nature of the topics that I find most interesting myself to deal with and to discuss. So I am going to bring up my my PowerPoint here to there we are. Okay, and give you the visual here. Sean will flag me down, I'm sure, if anything comes up while I'm speaking. And then otherwise, I'm going to take you through this topic. And there's not, there's very little text on the slides that we've got here. It's limited just to give us some outline to work with. And so I'm going to go through a half dozen topics, well, 5 here, but just to give you the header slide with the agenda. And the text that I've got on the slides is very limited. This is as much text as you're going to see here. It's not meant to be a great light show. It is intended to make sure that that we cover off against the high-level topics involved with estate planning and give you a chance to think about the why of the estate planning as much as possible. Quite often, people will be thinking of the stuff that they have, perhaps thinking, well, I'm not wealthy enough, I'm not rich enough to do estate planning. But obviously, because you're taking an interest, because you joined the session here, you do recognize the need for it. That is not about the money, or not so much about the money and the property you have. It goes well beyond that. So I'm going to take you through these topics and give you some of the perspective that I have on these topics and the conversations that I've had with people over the course of time, so that so you can see where it is I'm coming from with this. And so the first thing that I want to do is to step back a little bit. When people talk about estate planning more generally out on the street, if people do that on the street, it tends to be the belief, the thought that transferring your property is what estate planning is about, driven by that consideration. But I like to back it up and talk about it in terms of the people who are involved, because transferring your property, making out a will that transfers your property, is definitely a very important part of estate planning. It's an important document, and I'll come to that, speaking directly to the documents, the key documents that are involved. But really what estate planning is about the people around you and you yourself. And I've used this definition for years. It's very simple. It is that estate planning is about taking care of yourself now and taking care of yourself in the future, as well as taking care of the people around you now and in the future, and when you're no longer around. So when you're thinking about estate planning, and how you're going to take care of those other people, if all you are focused on is, if I've got a will, then I've got an estate plan, that really is a very limited view of what estate planning is about. And I'll distinguish in just a moment, I'll distinguish the use of those phrases, estate plan versus estate planning, because estate planning is what you're involved in. An estate plan is a little bit more of a nebulous idea of what that might be. It's not really a fully defined type of thing that is accepted everywhere, but estate planning as a process, as an activity you go through, is critically important to make sure that you are clear on who are those important people around you, and again, including yourself, and then how are you taking care of yourself and those other people. When I would go and see people in their homes, as I said, that was the nature of law practice as I was running in the early days. I would see people who, for whatever reason, whether it was an intention or a limitation, they did not want or could not go to see a lawyer in an office. And so I was seeing a lot of people in their homes and in their businesses if they were busy. And because of that, with the people I was seeing in their homes, there were a lot of seniors who I was seeing who could not get out, and therefore we were having this conversation across the kitchen table, having literally cookies and tea. And I was taken aback in some ways how many people who in that situation were very concerned about taking care of their families, as they certainly have the right to be concerned about, but put the interests of their families ahead of their own selves and looked at estate planning as being an exercise in making sure that as much as possible was transferred on to those kids, that next generation. And I'm talking to people who were in their 70s, 80s, and even 90s, whose own children were already into their own retirement, and they were concerned about making sure that they preserve things to pass on to their own kids. Who, kids is an odd term to talk about somebody who is fully retired. So it definitely is important that you take care of yourself first, as they say in the airplane. Put your own mask on first, and then put on the mask of the people around you, so that you are in really good position to be able to live the life that you're entitled to on your own, but also to make sure that those people you care about, who you are responsible for, you have a legal responsibility, a moral responsibility, an emotional connection, that you can take care of them as well as yourself. So that's the people who are involved in your decision making about who you're taking care of. And then the second part of who the people are is about the professionals who you are working with. If you look back a century or so ago and said to the average person on the street, who are the estate planners among the professionals that are available to you? Who are the estate planners? And I would think that almost invariably you would get the answer that it's lawyers who are the estate planners. And even today, I think that that would be the most often cited professional who would be involved. But as we get the Income Tax Act coming in, which was in 1917 that we had the first Income Tax Act, then we have taxes as a consideration in terms of just your year-to-year accumulation of wealth, as well as the tax implications upon your death that could seriously impair what you have to live and have your life with, as well as what is going to happen at the point of your death that could deplete your estate. So we have tax advisors of various sorts, whether that's an accountant or it's a tax preparer in a generic sense, but tax advice is a very important part of preserving an estate during your lifetime and at the point of your death. And as you roll through the decades from there, we have much more of an industrialized society. We're moving away from agriculturally based. We've got people coming more and more into the cities. We've got workplaces where people have pension plans that are available to them. So no longer is your retirement having a large family on the farm that they're going to take care of in your later years. It is about having some structured ways that we are saving our money. So we have pension plans, we have investment advisors, we have financial advisors providing support in terms of the insurance that might be available to us as the years and the decades roll on. And those types of advisors also have a very important role to play, because some of the biggest decisions you will make about your estate are about who you name as your beneficiary, running off of those registered plans, those savings plans, as well as what happens with the insurance that you have. So all of those professionals have their own respective expertise, but what is critically important is that they're all pulling in the same direction. What might make really good sense from a tax perspective might be completely the wrong thing to do from the perspective of your family, because you have certain needs, like somebody who has a disability or somebody who has some kind of an addiction that you don't want to have tax efficient money transferring over to this person that then causes more problems than it relieves. So make sure that all the professionals are pulling in the same direction, that they're aware of one another at the time when you're making plans, and that you keep them in contact. It's not a constant thing, but that they're aware of one another and they're pulling in the same direction. And the last point here about beneficiaries is that we tend to think of the term beneficiaries as relating to a will. So naming people who are going to receive either the property or the income of the property or both through a will. We can also name people who are beneficiaries under those registered plans and under insurance, so that they are not going to receive via the will, they're going to receive something through the various plans that we have. But even more broadly than that, you need to think about who are all the people around you who you want to take care of, whether or not they are directly named as beneficiaries under those plans or under your will. How might you take care of those people? And when I say how might you take care of them, what I mean is, are you going to provide for them during your lifetime, transferring on your property? Again, the estate planning is about taking care of yourself. I what do you call it, a repeating record on this. Take care of yourself now and in the future, and take care of the people around you now and in the future, and when you're no longer there. So that's your priority. But then the property you have, the transfer of your property, is what fulfills on taking care of those people. So you could transfer during your lifetime. You could transfer at the point of your death through one of those beneficiary designations on the plans, or through your will. And then you can get further on beyond that to look at the people that you're taking care of, that it's not just an outright transfer, but maybe there is good reason why you need to still have strings attached to how it is that you're taking care of them, whether you transfer to them now or at the point of your death. And that's where we get into a little bit of a discussion about trusts. So I'll come back to that in terms of the key documents and the key structures that you can use with your estate planning, the use of trusts as a way to do that. So that's the point about the people who are involved. And now I want to turn and talk about this notion of an estate plan versus the estate planning process. And there's one of the generals, I think it was General MacArthur, the US general, there's a quote, which is, whether it's his quote or it's attributed to him, the idea that that battle plans, as he said, battle plans are useless, but battle planning is absolutely critical. And that likewise is the way that I look at estate planning. The idea of there being an estate plan, that you pull some kind of a document or a box off a shelf, you fill in the blanks, and you have a universally recognized estate plan. There really is no such thing as an estate plan. But estate planning as a process of going through the inventory of yourself, and I mean the personal inventory as well as the property, but who you are, what are your goals to take care of yourself, and who are the important people around you that you need to take care of. That process is what you're doing in order to determine what is the best way to take care of yourself and those people around you, and not trying to escape it entirely, transfer on the property that you have. So the subtitle that I have here is "The Method is the Message," like Marshall McLuhan, the Canadian from decades ago, who talked about the medium is the message. So going through the process of thinking about the important people around you and the needs that they have, that you have, that's what we're doing when we're going through this estate planning process. It's a consultation process that you go through. You are talking to professionals who you want to get the most of their skills applied in your circumstance. So it's a consultation with them about what they have to offer in terms of their skill set. And specifically, when we're talking about lawyers as professionals, what kind of legal and specifically estate planning legal skills that they can offer to you. And then eventually there's going to be the production of documents that will support that. But it's the informing of the process you go through in being able to sit with someone who has experience. That's what you want to get when you're dealing with the lawyer. And I use this phrase sometimes, expert meet expert, to mean you as the person who is looking for support in your circumstances, you want to make sure that the experts you hire, and in this case lawyer, but it's true also about any kind of expert, whether we're talking about the tax professionals, investment, insurance, whether we're talking about any other kind of skill set of professionals, you want to make sure that you're getting the most out of them that they have as this particular area of expertise. So you have to meet them halfway, at least halfway, where when you have questions that are being asked about you, because it's to be applied in your circumstance, that you're forthcoming with that information. You are the expert in yourself. And that's where I have this expert meet expert, expert in the particular area of expertise or technical expertise, like the law, and then you as the expert in yourself. And so when the two of them meet, then we can apply this skill set, this area of expertise in your circumstances specifically. And in terms of interacting with the lawyer, one of the things that you be comfortable with is that the legal relationship, the solicitor-client relationship, it is the most highly protected legal relationship under the law. So the things that you discuss with your lawyer, those are confidential. If there are some, unfortunately, embarrassing or just sensitive issues that you don't want to discuss, more generally, it's important that you understand that your lawyer is not going to then go to a cocktail party and talk about you or disclose those things to other people. There is a legal responsibility on them to maintain the confidentiality of what it is that you're disclosing. And that allows you then to be as open as possible so that if there is some kind of unusual issue, it can be addressed, it can be dealt with, and you can put plans in place as much as is possible to make sure that it's not going to cause problems for you, or that you can minimize whatever the issues might be. So that's the roles that you have between you and the professional you're dealing with. And last point here is about having a balance sheet to begin this whole process. So what I'm talking about here is, as I said, you are doing estate planning because you're taking care of yourself right now and on into your own future. That's your first step of things, and then taking care of the people around you. So in terms of taking care of yourself, you have to know where you are to know where you're going for yourself, as well as taking care of the people around you. So why I say the balance sheet is the place to begin is because you have to know what property you have. You have to know what are the sources of the property that is going to come to you in future. What is it right now? What is the flow of the assets that you have? What is the nature of it? And specifically, when I say nature, I mean, what is the tax nature of it? Again, that's part of my background, as well as being a lawyer. I've got a legal degree with tax. You want to make sure that you understand, not that you would know it top of mind, but you appreciate that some of the things that you own are after tax things. Some of the things are eventually fully taxable, like your RSP, for example. At the point of your death, it becomes fully taxable. You can roll over to spouse, but it otherwise is going to be fully taxable at that time. And there's other things that you might own that are somewhat taxable, and so some of that is going to be intact, and part of it is going to be subject to tax, like some rental real estate, for example. When you sell that property, whether you do it during your lifetime or at the point of your death, you're going to end up having to pay some tax on the capital gain that applies there. So what are the sources of property that you have? What is the tax nature of them? And as long as you're informed on that basis, then you can make your own plans, your financial planning for the course of your lifetime, as well as being confident that who you are taking care of and how you are taking care of them actually will be as certain as possible as you put these plans into place. So start off by making sure you've got a reasonable picture of your financial planning, and then you can look at how you take care of yourself and the people around you. So as I said, this is probably as obvious as it gets in terms of the white space that you're looking at, rather than looking at the text that I'm throwing up on the screen. As I said, we are getting the consultation with the professionals, with the lawyer, so that we can eventually put a plan in place, and so produce the necessary documents, make sure that they are executed properly, so they carry out our wishes. And the key documents that I'm showing here, and I use the short form phrases here because I speak across the country, and the terms change from one province to the next. But the key documents are the 2 powers of attorney for property and for personal care, and the will, and potentially setting up 1 or more trusts to take care of things. So I'm going to start with the powers of attorney. And I think that a lot of people would understand what a will is, at least in a general sense. It's the document that speaks from the point of our death about our property. But powers of attorney are a little bit less understood, more so now over the last, really about 3-4 decades, that it's come more into prominence as we've got an aging population. We have people who are living into later ages and might go into declining mental capacity. And so it has become, and it continues to be, a much more prominent discussion than it was 3-4 decades ago. So the law of powers of attorney is actually originally coming out of judge-made law, the common law, English common law, where judges would make decisions, and then those decisions would layer upon one another to form a particular area of law. And powers of attorney as an area of law is a type of principal and agent law. So someone who owns property in the first place, and in our case in Ontario, that's the grantor, the eventual grantor of the power of attorney. Someone who owns property is going to name someone else, one or more, who will be able to make decisions about the grantor's property. Under the common law, and this goes back hundreds of years, and back in the Middle Ages, that the common law was dealing with power of attorney. Under that law, the judge-made law, a person could name someone else as their attorney. An attorney here does not mean lawyer as you see it on the US television or movies. It means a decision maker. So someone names another person as a decision maker about the property of the grantor. Under that judge-made law, under the common law, if the grantor became mentally incapable, then the power of attorney no longer acted. The legal effect of it was gone at that point. If you think about that in modern times, the time when we generally want for that person definitely to be able to act is when we, as the grantor of that power of attorney, become incapable of making decisions for ourselves. We want to have someone who is that safety net to make decisions about our property. And so long ago, a century or so back almost, the provinces, which have the responsibility for property matters under the Constitution, all the provinces have enacted legislation that now has acts in the provincial legislation that allows for the naming of someone as an attorney for yourself under the powers of attorney legislation. And in Ontario, it's called the Substitute Decisions Act. So you can name someone who can make decisions about yourself under the Ontario law. And here's the addition that was critically important, you can name that person who will act in that capacity and will be able to continue on doing that even if you yourself lose the ability to make decisions about your own property. So when you hear that word continuing power of attorney, or in other places it's called an enduring power of attorney, there's a couple other phrases, but those are the two most common. What that means is, if you name someone and you give them the authority to continue to act, you don't have to, but if you give them the authority to continue to act, even though you yourself are unable to make decisions, then that person will be able to continue on. Absent that, if there are important decisions to be made, then there may have to be an application to a court to have someone named as guardian of you and custodian of you for your property and for decisions about you personally. So you get the ability through this document, through this process, to name, again, it doesn't have to be one person, but one or more people to do this. The other bit of a hole in the English common law version of powers of attorney is that it only applied to property, the things that you own. But under the legislation as we have it now, you can name someone who can make decisions about you, and that's called the power of attorney for personal care. And this may very well be the same person, and quite often it is, back and forth between spouses. Quite often people will name one another and then maybe name as a contingent, should the other of the spouses not be available, then one of the children of them, you can choose who you want, but that's commonly what might happen. One of your children might be the alternates, or maybe two or three of your children might be the alternates apart from you as spouses. And of course, if you don't have a spouse, then you're not even going to start at that back and forth kind of view of things. You're going to have to look around you and say to yourself, who do I trust? Who has the capability of doing this and making sure that I'm taken care of, both for the property purposes and for the personal care? And you don't have to name the same person in both respects, although usually with spouses, that's exactly what happens. But at the second stage, maybe you break things out a little bit more according to who's got the appropriate skills and knowledge to carry out the different functions of decisions about your property versus decisions about you. And when I say decisions about you with the personal care power of attorney, that's things like medical. So if a doctor is looking for consent to medical treatment, that's part of it, and just general health care. But it includes things like where you're going to live, socially, how you're going to spend your time, things having to do with about you personally, nutritional decision making. All of those types of things are under the power of attorney for personal care, and the power of attorney for property covers all the things that you have, that you own. And when I say property, that includes, some people might say, oh, well, is it property? And then you've got another one for financial decision-making. That is the power of attorney for property. Financial decision-making, decisions about the things that you own. That's what those powers of attorney do. So those operate during your lifetime. And then when you die, powers of attorney cease to be effective because unfortunately you're not there anymore, but your property is, and your will speaks from the point of your death to say what is going to happen with the things that you own at the point of your death, who is going to receive that. As number one, that's what the purpose of a will is. And then secondly, who are you going to put in that position to take care of the property and then distribute it out to the people you name as your beneficiaries? And that person is your executor. Now, executor is a generic term now. The term is not used, it's used in some jurisdictions, but not in Ontario anymore. But we tend to still use that phrase. It means to execute the instructions in the will. What we have as the formal title here in Ontario now is the estate trustee. So the person who is put in that role becomes the new legal owner of your property at the point of your death, but with the responsibility as the legal owner to take care of that property for the benefit of the people who are named as the beneficiaries. So that's your will and how it operates. And then the last thing I want to touch on here is the use of trusts. Now, I used the phrase already, estate trustee. What a trust is breaking out ownership of property between legal ownership, so who's on title to whatever property you're dealing with, who has the legal authority to give instructions on that property, versus who is going to receive that, again, whether it's the income of that property or selling that property and then the proceeds of that sale then go to that person or that beneficiary, because you could have a corporation or a charity as a beneficiary. So what you can do with a will is, or what you can do with a trust, is you can break out the ownership. And I look at the trust as being this triangular shape. So up here at the top point of the triangle is you owning certain property. And if we're talking about your estate, it's everything that you own at the point of your death. And what you're doing is you're naming someone who is going to be the new legal owner of the property down here at this point of the triangle, who will then have the legal authority over the contents of this triangle, which is your estate. And then this person who is named as the trustee, the estate trustee in this case, has to manage that property for the benefit of the beneficiary. Again, we could have multiple beneficiaries involved. So you can set up trusts during your lifetime or at death. I gave you the example there where it happened through the will, with your entire property falling into your estate with no specific trust that you set out beyond just everything being taken care of and then distributed out to the people who you want to take care of as soon as the executor is taking care of all the legal obligations, paying off creditors, paying your taxes, and then distributing it out to the beneficiaries. But as I mentioned, there are some situations where you might need to name someone to carry on, to manage the property for someone who is frail for whatever reason. As I said, somebody might not be able to manage property because they have a disability, or it might be somebody who would otherwise be able to manage property with having a disability, but because that person might lose out on government support if they directly own the property coming to them from the estate, then you can set that up on a trust basis so that person continues to get the government support, and then the property that is coming out of the estate can then be given to them from time to time by the person who is the trustee, so that you get both ends of it. You get the entitlement from the inheritance and the continuing support from the government. There's lots of reasons why you set up trusts beyond those. If there is creditor concerns of the person who's beneficiary, if you have them receive their entitlement directly, then the creditors might swoop in and take it. So maybe you set up a trust for that reason. If you've got minors, underage beneficiaries, they don't have the legal capability to receive property, and so you need to name someone as a trustee for them. So a variety of reasons why you might want to keep the strings attached when you're setting up your distribution of your estate. And that's what we do with a trust. It's not the only way that you could do it, but it's most commonly what you will do is to set up some kind of trust terms before distributing. So just a couple more points that I'm going to make. I'm not going to go into the great detail on these last couple of slides that I did on the first few. I'll wrap up in about 3-4 minutes here. The priority sequence of things is, as I said, to make sure that you are taking care of yourself now in the future and the people around you now in the future when you're no longer there. But people do like to save costs. And so the question comes up, well, what about trying to reduce probate costs? So the idea of reducing probate costs is a good idea as long as you don't throw out the plans that you have to take care of yourself and the people around you. And probate as a cost is a process where the will of this deceased person, as long as it was executed properly, is the legal authority for the distribution of the property of this person. But the executor holding on to this document needs to be able to take on that role, to become the new legal owner of the property, to gather in the property of the deceased person. And those who have control of that property currently, so that could be the common example is a financial institution has the property. They don't know if this document is a forgery or if maybe there was a later one that superseded it, or if there is some kind of other fraud going on that this person hasn't even died yet, and this is a bit of a scam. So in that case, what can happen is the financial institution or anyone who is looking for clear authority of this purported executor to take on the role will say, could you probate that document? And what that means is that the named executor will go through the court process, fill out the forms that are necessary to confirm that this is indeed the last will of this person. And when that happens, then the court, well, this is the government, but through the court process, the provincial government will levy a fee on that. And the fee is 1.5% of the value of the property in the estate, other than the first $50,000. So you don't pay any probate tax on the first $50,000, but otherwise 1.5%. So that comes out to, other than the first $50,000, it's about $15,000 of probate tax per $1 million of assets. So never more than 1.5%, and it goes by province. Ontario's is 1.5%. Some provinces it's a lot less, almost non-existent in a couple of provinces, and then it's a tiny bit more in a couple other provinces. So keep that in proportion, that you don't want to be making your decisions based on this relatively small tax. But you can get around it in some reasonable ways without completely messing up the plans. So I mentioned about naming beneficiaries on registered plans, whether that's RSPs or RIFs or pension plans. You can name beneficiaries, and then the contents of that plan goes directly over to the person who is named as beneficiary. Similarly, on insurance contracts, on life insurance particularly, you can name a beneficiary that does not go through your estate, so it's not subject to probate if you name someone as a beneficiary. Second thing that is commonly done is to own property under joint ownership, where you can hold property between or among multiple people, so that when one of those people dies, the other people who are on title to the property continue on by what's called right of survivorship. So joint with right of survivorship. You'd see that most often with spouses, two people as spouses, but again, you can have more than just spouses involved with that. It's pretty much the default for the majority of the assets between spouses to do that, whether we're talking about real estate or we're talking about investment accounts, non-registered investment accounts, registered being like RSPs and RIFs, which can only be named, owned in one person's name. So you can have a joint ownership arrangement with spouses or with non-spouses. The problem you get into with non-spouses potentially is that you may have taxes applying when one of those people dies and the transfer goes over to the survivors. You might expose to creditors by adding on an adult child, for example, or potentially exposed to matrimonial claims in future. Whereas between spouses, you have a fairly clear identity, not identical, but identity of interest between the two. So that tends to be the default. But if you have others other than spouses that you're contemplating doing this with, then just be careful that that you get proper tax and legal advice before going through with that. But once again, the death of one of those joint owners does not cause that person's interest in that property go into their estate. It goes over to the survivors, and therefore probate tax doesn't apply. And the last thing here is that if you give things away during your life, then that doesn't belong to you at the point of your death, and therefore your will does not deal with that. Just have to be careful again that you make sure that you're not giving away everything that you have so that you are really beholden to the people around you to take care of you all the time. You want to make sure that you're not putting yourself in a difficult position by giving away everything. So just last couple of points, and then Sean, I'll bring you back in here. Critically important is that you are well informed as possible about what you want to do. And that includes making sure that the people around you, what your intentions are, that you are aware of what they are likely to do once you are transferring your property to them, or if you're going to name them into a particular position to act as an executor, for example. So it's a good idea to communicate with the people around you. There's not a legal requirement, but to let them know that you're thinking through your estate planning, and so you want to get their input. But it's your decision about what you do, and then recording information for the sake of giving them a starting point, giving the executor particularly a starting point. And we've got a form that we can share with you, Sean. I believe we've got a estate planning information form that we can share with the people here that will allow you to record the important people around you, the professionals you deal with, and the key property that you have. And then the last point that I want to make here about reviewing, people will say, well, how often do I review my will? And I'll put it into three categories. It might be a matter of time, and there's nothing magical about it, but I say about every 5 years, it's worth checking in with a lawyer, because at that point, there would have been a couple of elections, at least one, maybe two elections, provincially and federally. So the rules might have changed. They don't change very often, but they may have. So about a 5-year point to check in. Second thing is if you have a significant change in the property that you have, if you intended, for example, that a cottage go through your estate to one of your children, but you've since sold that property, that might change the distribution. So significant change to the property that you own would give you reason to revisit your will. And then the last thing is if there's been a significant change with the people around you. That so again, coming back, take care of yourself and the people around you. If there has been a birth, if there's been a divorce or even a separation, if someone has gone bankrupt or had a significant medical issue, if they've gone non-resident, even out of the province, another province, or if they've come back, those kinds of things having to do with the people may give you reason to again revisit things. So have a further conversation with the lawyer, call them up, and they'll probably ask you to come in, sit down, and talk through things. So I'm going to hold off there, Sean, and bring it back to you and see what questions we have there.
Well, thanks, Doug. I mean, I was feverishly writing down. There's many interesting points there, and I think we've just scratched the surface, really, because when you think about it, you want to involve a number of people. Whether it's a lawyer, a planner, someone who would assist the state services or executor services. Pardon me. It is really, as you said, not a plan but a process. And it can become very complex, right? As your situation changes, whether you have a blended family, maybe a business, other multiple types of properties, it does require some level of advice. But I do want to get to some questions because there's a number of questions that came in, and there are a lot of similarities with some of them. So the first one I do want to go to is a question that we did receive, prior to the webinar is, what about a foreign property? So you have property that is, outside Ontario or Canada for that matter, whether it's property in the US, maybe it's a vacation home, or maybe you're a snowbird. How is that impacted when it comes to the estate planning process.
Okay, and I'll leave aside the bulk of the tax issues because that's an issue in owning property, any property. There may be tax issues involved with buying and selling, so I'll leave that part aside. But just sticking to the core of the estate planning considerations, your will that you execute here in Ontario, it is going to be able to deal with your real estate located here, but it also governs the rights of any personal property you own. So the world breaks into personal property and then real property being real estate. So wherever you own things, personal property on the face of the earth, your Ontario will deal with that. But real estate, if you've got real estate, and let's say that it's in Arizona, in order to deal with the property in Arizona, you would have to have your will here in Ontario probated first, because you'd need to have the court authorization. And then you'd have to go, you're dead, mind you, but the person who's acting on your behalf would have to go to Arizona and then prove your Ontario will in that state, if that's where you've got your real estate. So one of the general recommendations, if you have property in another place, in another province or another country, and particularly the US, is to have a will in that location that runs alongside your home jurisdiction will, your Ontario will, as well as powers of attorney in that jurisdiction. Because again, if you need to have use of those, or somebody needs to take care of you when you are there, then you don't want to have them jumping through hoops with the legal system. Better to have had someone in that jurisdiction draft up a document which was known to that jurisdiction, so that it will facilitate that as much as possible when the unfortunate event happens, and that you don't have that person jumping through hoops at that point. The one thing about that has to be really carefully managed, though, is that it does not revoke your Ontario will or your Ontario powers of attorney. So it's a carve out just with respect to that jurisdiction to coordinate with your home jurisdiction will and powers of attorney.
Thanks, Doug. It's somewhat related to the next question again, which we received a lot of comments on. Is one of the things you mentioned is joint ownership, and a lot of many of the questions we do receive is with respect to a member who has a child who they'd like to add on to their principal residence or their real property. And I understand that there can be nuances to this strategy, pros and cons. So perhaps you could just maybe address those real quickly here.
Okay. So I'm not going to suggest to you that, no, never do that. I understand that in a family situation, you do want to, you expect that things are going to pass between the parents and then down to the kids, but you just have to be careful once you get to the stage of adding the kids on a joint ownership to the property that you own. So the challenge with it in part is that between spouses, we can transfer property without triggering capital gains. So the growth and value of our property is not taxed until there is a disposition, but we can roll over between spouses. So when one dies under joint ownership, it just rolls to the other. But once you add on a child, then you've got a disposition happening. So if we've got two parents with a single daughter of them who is their only child, the focus of their entire lives, that's who everything is going to go to. If they say, well, then why don't we just add her on to the ownership of this property? And I'll treat it as this being a rental property or vacation property. The problem with doing that is if you add her onto that property, then you have two owners to start with, husband and wife, and then you've got the daughter. When you add her on, that third person added, you are deemed to dispose of 1/3 of an interest in that property at that time. And then you're going to have a capital gain arising for mom and dad as the current owners when that happens. And that's going to be an unfortunate surprise when you're talking to your accountant leading up to your tax preparation next April. So that's the concern, the income tax concern. If you don't have proper documentation, you don't carry it out properly, then you're going to have to pay tax on adding her on to that property. The fallback to that is say, well, yeah, but I don't have that property. I've got my principal residence where I'm living in, and the principal residence isn't subject to capital gains. What's the concern in that situation? And the concern there is now you've got mom and dad who live in that property. You've got daughter who's added on, who lives in Sudbury, not here locally in the local area. And she's got her own house out there. So now she's on ownership of this property, and the capital gain on that, it is protected for mom and dad because it's their principal residence, but it's not protected for the 1/3 interest that daughter has. So though you would have no capital gains tax arising at the point of adding daughter on, the future growth would be subject to some degree of capital gains related taxations. Those are the kinds of things you have to be careful about. There are workarounds to that. You can talk to a lawyer about that. But if you do it without proper documentation, then you're really opening yourself up to some unfortunate tax result.
Very, very interesting, because I think a lot of folks simply think, well, I just add them to, the property and it'll transfer seamlessly, right? Based on right of survivorship.
Yeah.
And that sometimes, you really need to seek some good advice to make sure that, you don't put yourself into a bit of a pickle in that situation. What you did talk about minimizing probate, and, obviously everyone's concerned about taxes. If this is one thing that, people don't like to do is pay taxes, and try to avoid it. And we don't want to say, that we don't pay our fair share, but we want to see if there's ways to minimize, not avoid, but minimize, I guess is what I'm saying on the tax side. How important are charitable contributions to help minimize some of the tax liability when it comes to the states?
Well, I think that you start off with the basis that you have a charity of some sort that you support, and based on that, and wanting to continue to support them during your lifetime and at the point of your death, how can you do that in as tax efficient a way as possible? And some people say, well, that's being greedy. If you're going to support the charity, just support the charity. But the way I look at it is if you understand the tax rules, then you can either give more because you are aware of the tax rules, or it can cost you less to give the same if you understand the tax rules. So you still have to come back to the need to have a charitable intent in supporting the charity that you care about, because when you give to that charity, you are giving away what you have, and then because you give away, you are entitled to tax benefits when that happens. And there's a difference when you have the donation that you do during the course of your life versus doing it at the point when you die. So you can name a charity as a beneficiary under insurance, under registered plans, as well as under your will. And depending on which way you do it, then the tax results, the tax benefits of that will apply in different ways, not ridiculously different ways, but you need to look at that and say, what am I trying to do? What is the best way to do this so that I make sure I support the charity that I care about and that I get the most tax benefit from that? Again, whether you're intended to give the tax benefit effectively to the charity or preserve as much to then pass on to your family beneficiaries, apart from how you're supporting that charity.
Great. Doug, one of some of the questions that have also come in is, when we talk about, what we need in place when it comes to wills, for example, POA documents. Nowadays, do you go to a lawyer? There's lots of online resources to set up a will. Do you have a particular recommendation on where to begin in that process to set up your will?
Yeah, I this is not me. I'm not actively in practice anymore. I've worked in this kind of a role where I work with financial advisors and I'm a resource for tax and estate conversations with the advisors, with their clients, with their members. And I did run law practice though for quite a while. And the whole idea of doing a do-it-yourself will, I would say that in a lot of cases, it will not have mattered whether or not you made use of a lawyer. But in those cases where it does matter, it matters in an extremely serious way. It could be that you have a complete mess that's created if you get it wrong. And as much as I know people are looking for efficiency in doing a will and not having excessive costs involved with it, you just have to be very careful that at this relatively random event, the point when you die, everything merges at that point, and all the decisions you've made over the course of your lifetime will then come together to either work out or create uncertainty. And what you're doing when you're making out a will is you're trying to get certainty as to what will happen. Again, I can appreciate people wanting to do the do-it-yourself wills, and that there are some very good computer programs which can lead you through the process, and you can fill in as it's guiding you to do that. But still, I think that you really need to make sure that you get a review from a lawyer as to whether there is something that you need to be doing outside of that. Because sometimes the decisions you make about how to transfer the property will mean that you don't include things in the will. So if you have a really well put together will and everything goes through the will, but then it should have, in ideal circumstances, bypass the will in some way to go to those people you want to take care of, it's really difficult to get that kind of advice from a computer program. So I just be very careful about it. And I understand people will do that, but just be careful if you've got any kind of complications, a second marriage, anybody who's got any kind of disabilities, anybody who's got frailties, addictions, spending problems, those types of things, make sure that you give some serious consideration to talking to a lawyer rather than trying to just go it on your own.
Yeah, no, it's interesting you say that, Doug, because having a simplified process or program to draw up a will, it can be great. But to your point, if you have a unique, specific circumstance where you may want to directly have the ability to transfer assets to a beneficiary, at the same time bypassing probate in some cases by using, for example, a segregated fund or an insurance contract of some type, that remains outside the probate process. And thereby, it's a direct transfer of the funds. And that might be a better way to address that. So I think it's really important to understand, as you said, plan for yourself first, and then plan for, your needs beyond. And, the use of a financial advisor, planner, lawyer are all important pieces to, ensuring that you have a good estate process in place going forward. We've had a number of questions come in, and we'll try and get to a couple more. We are running close to the end of our webinar, and certainly there are many, many things to go through. And so I apologize if I'm scrambling a little bit, because I am looking at all the questions coming in. Let's go back to the POAs for a moment, Doug. On the POA side, if you have a joint POA, the question has come up, where do both POAs have to make a decision together? So I have, my parents who have assigned myself and my brother as POA, and something happens, and do my brother and I have to jointly make the decision, or can that be disputed between the two of us?
Okay, so there's two main ways that you can name people to act as attorneys. There's what's called joint and several. Under a joint designation, they have to do everything lockstep. All decisions between them have to align at complete agreement. And then under a joint and several, either of them, if we have two or three, doesn't matter how many, or any of them, can act on their own as your attorney in that case. So you're setting it up so that there's a lot more flexibility. So that's really the trade-off is, do you want security by having it joint, but possibly very complicated or very cumbersome? Or do you want flexibility, but then opening it up to the possibility of abuse in that situation if one of them goes rogue and does things that they really shouldn't do? So those are the main distinctions: joint and several.
Great, Doug. And I guess, we've been talking about, having the plan, preparing for the plan, speaking to the right advisors. But I think what we need to also understand is, what happens if you have property and you don't have a plan, you don't have a will, and you die, I guess, intestate? What occurs at that point to your property, to your assets, and to your estate without a proper plan there?
So if you don't have a will, then, as you mentioned, Sean, it will be referred to as an intestacy. So you don't have a will, meaning that, or the implication being that there has to be some kind of distribution. And so the rules of intestacy in the province then distribute your property among the people close to you, but not necessarily in the proportions which you would have decided. So it will remain within the family structure, and it works outward from, if you have a spouse and you have a relatively small estate, your spouse will get everything. Or if you have a spouse and one or more children, your spouse will get a first portion, and then it will be shared among them. And you work your way outward. If you don't have any blood relatives, then it ends up that it goes over to the Ontario government, which is actually a client case that I had a couple of decades ago, where it was farming property, very large farming property in Middle Ontario, where the Ontario government became the owner of a farm because there was just nobody related to this person, and there was a will, but the will did not anticipate if the other person, and the other person was actually my client, if the other person predeceased, and she did. So there was no living person to carry on, and so it went to the Ontario government. Again, very seldom does that actually happen. It's usually somebody close to you, but you lose out on your opportunity through your will to set things up with the timing and with the strings attached as necessary that you would want to have if you did your own will, that you don't get if you don't have a will.
Great. Doug, thank you so much for this lively discussion. Folks, we will have the recording available to you. We will attempt to go through all the questions that we received. Unfortunately, we cannot go through them all, given the time constraints that we do have. We will be doing a follow-up webinar on this very timely topic, and perhaps, and Doug and I will plan for that. I believe we're having one early in the fall at that point, but keep an eye out for that invitation. If you like this webinar, we will send out a survey. We would love to have your feedback, and also any suggestions where we can improve, or any topics that might be of interest to you. Again, if you have questions or you're looking for additional guidance, you can always speak to a wealth advisor at Alterna. You can also send questions to wealth@alterna.ca, and we'll be forwarding those on to our wealth advisors to help assist you. Doug, thank you once again, and I hope you enjoyed the webinar. This concludes our webinar for today.
Thanks, Sean.
Thank you.